Good morning, everyone, and welcome to Diritto al Digitale. I'm Giulio Coraggio. I'm the head of the Italian Intellectual Property and Technology Department at the law firm DLA Piper. Our mission goes beyond simply interpreting existing rules. We aim to shape them. We strive to create the law itself, bringing legal principles into uncharted territories that lawmakers never even dreamed of. Today is an important day, and that's why I'm joined by my colleague Tommaso Ricci, that is part of our team at DLA Piper. Welcome, Tommaso.
Hi, everyone.
Today is an important day because the European Data Protection Board issued a highly expected opinion. The opinion provides significant guidance on how the GDPR applies to the development and deployment of artificial intelligence models. In response to questions raised by the Irish Data Protection Authority and addresses 4 key issues. Our goal during this episode is to unpack these guidelines, illustrate their implications for businesses, and touch on the recent cases impacting an Italian publisher that reached an agreement with OpenAI, and the reaction from the Italian Data Protection Authority, also addressing the position of the ICO, the British Privacy Authority. But let's start from the beginning. Tommaso, let's begin by setting the stage. So the opinion was prompted by a request from the Irish Data Protection Authority on how GDPR principles apply to AI technologies, a very hot topic that is on top of the list of many organizations that are struggling to understand how established data protection principles apply to AI models. The opinion covers whether AI models can be trained on personal data, whether this data can be considered anonymous, what is the legal basis of the data processing, and what are the consequences on unlawful data processing during the AI model development, and the importance of documentation, accountability, and risk management throughout the AI life cycle.
Exactly, Giulio. As companies accelerate AI adoption, understanding these guidelines is essential. I think that what makes this opinion particularly significant is how it carefully defines its scope. The board is introducing a precise definition of AI models. We don't have a precise definition within the AI Act. We do have now within this opinion. And it explains that while they are essential components of AI systems, they do not constitute AI systems of their own. The opinion scope extends well beyond just large language model and generative AI. So it encompasses any AI model that results from training with personal data, whether it's used for customer service, fraud detection, or even content recommendation.
Yeah, one of the points on which the opinion focuses at the beginning of the paper is whether data on which AI is trained can be considered anonymous. This was one of the points that was the subject of guidelines from the Hamburg Data Protection Authority that were heavily discussed. And actually, the Hamburg Data Protection Authority commissioner was the guest at one of our recent events. The European Data Protection Authority adopts a very cautious approach on anonymity that is difficult to achieve. Is that right, Tommaso?
Yes, exactly. And I'm also afraid this diverges from the previous position of the Hamburg Data Protection Commissioner. The opinion emphasizes a case-by-case evaluation is needed, setting a particularly high theoretical bar for what is anonymity and when it can be achieved. So according to the board's approach, even if a model does not directly output personal data, organizations must prove it cannot inadvertently memorize personal details. So this is technically a quite difficult thing to prove for a company. So the board is especially concerned with advanced querying techniques, and we have seen all the way throughout our social media examples of these attacking, where attackers perform model inversion or inference attacks to extract personal information from the model. So what the board is requiring now is for organization to demonstrate robust safeguards through a comprehensive documentation. They specifically mention techniques like differential privacy to inject noise and reduce re-identification risks. Again, this is quite difficult and can be expensive on some ends of the processing. While pseudonymization, which is a wider known security measures that we have been seeing applied so far quite a number of times, that can help. However, the opinion makes it clear that pseudonymization alone won't reach the anonymity threshold. The ICO, so the British Data Protection Committee's Commissioner, they have published this week their policy with their positions on generative AI, which sets out also the further work that has to be done after the initial request for proposal opened and during January of this year. So what they're saying here, they're taking a quite different position. They place greater emphasis on practical steps organizations can take to protect personal data, such as data minimization strategies and even filtering mechanisms before starting the training.
Yeah, I mean, it seems that the threshold of anonymity is extremely hard to achieve, to the point that even a sophisticated threat actor, a cyber attacker, shouldn't be able to re-identify individuals. Only if that is possible, then the anonymity threshold is achieved, because we've been dealing with many cyber attacks, and we know that a threat actor could could attach to an AI model a bot, querying the system multiple times and trying to retrieve personal data. And the scenario might become even more complicated with the evolution of technology. Tommaso, another topic that is extremely hot is what is the legal basis of this AI training? It can be legitimate interest. It should be only consent. Well, I would say that the good news is that the European Data Protection Board doesn't say no, legitimate interest is not an option. There is at least an open door. The threshold to rely on legitimate interest is again complicated, but we know that things, when it comes to privacy compliance, the solution is never too easy. So basically, the company needs to identify the legitimate interest, which cannot be just a mere commercial interest. It should be a real interest. So, for instance, the development of an AI agent that can support customers, can enhance fraud detection, can provide actually a benefit to individuals. We need to assess necessity, whether the processing is essential to achieve that interest, and whether the minimum amount of data necessary to pursue that goal are processed. So the data scraping cannot be just of any possible data. And then you need to run a balancing test, so balancing the interests of the controller with those of the individuals whose personal data are processed.
Yeah, Giulio, I think this is the good news of this opinion that we have been reading today. So there is definitely a door open to legitimate interest. And I believe that the approach that the board has shown is constructive. and notably even more flexible than what we have seen from other EU data protection authorities, or even the ICO latest guidance, which suggested that developers might struggle to justify legitimate interest and should consider also licensing agreements with publisher. I know also that in the UK there's a new proposal on how to balance, copyright and right holders' defense with the interest of making AI experimentation move forward. So the ICO and also the board are really focusing a lot on the balancing test. So this balancing act is really critical. Organizations must document their reasoning, also through a data protection impact assessment where possible, so going more granular, more in detail, and also provide evidence that the chosen approach is proportionate. So if you're using third-party data, for example, such as web-scraped content, the supervisory authority might be more skeptical. We know because also the issue of the transparency when it comes to reaching people you do not have a direct contractual relationship with. And in this case, lack of transparency or failure to inform data subjects could undermine the legitimacy of relying on legitimate interests. So I like the ICO's point of view in asking controllers to set out specific clear interests, even for models that can be used for various downstream purposes. But I believe that companies will need to focus even more on this balancing exercise.
Yeah, absolutely. And also, I do believe that to enhance transparency, legal design will have a pivotal role. Individuals need to understand how their data is actually processed. Sometimes we notice that the reference to the data processing for AI training is just hidden in a subsection of a very long privacy notice, which even privacy experts are struggling to spot. So think about a common consumer that will never fully understand how their data are processed. Our team at DLA Piper has developed a legal design line of business. We have legal design experts. That is a market where I do believe companies should invest more. Another question, Tommaso, is what happens if a company is adopting an AI model that is trained unlawfully? So the provider has developed an AI model and then sells the product or licenses the product to its customers. Customers are companies that are adopting that solution. The question is whether the company adopting that solution can lawfully process that data, can lawfully use data, that solution. So the European Data Protection Board presents different scenario. If the same controller continues to use the unlawfully training model during deployment, according to the supervisory authorities, the company using that solution needs to reassess the lawfulness at the new stage and determine whether additional legal basis or remediation steps are needed. Then the other scenario is if a different controller obtains and deploys the model, that in that case, the new controller must conduct a due diligence to confirm compliance, while ignorance is not just a defense, it's not a no-brainer. While if personal data is anonymized before deployment and no personal data is processed thereafter, the GDPR just doesn't apply. But we have seen, Tommy, that this is extremely difficult to achieve.
Yeah, that's really rare. And I think these all remaking the assessment things, it makes sense to me because we know that, these AI models can really be applied for a wide variety of purposes. So in the end, it's the actual controller, So the deployer of the AI system, which knows how they will use this model and whether this will lead to further processing of personal data. I also believe that this is, of course, making this assessment a little bit more complex because it is a multi-phase assessment. And in some cases, especially when there's a relationship between two parties, the latter shall make sure that has all the information that they need to perform this assessment while contractualizing the former. So being sure that they are able to get all the information they need to then make this assessment from the developer. Also, I think that this scenario, it places accountability on everyone's shoulders and on every subject involved in the AI lifecycle. Buyers of pre-trained models should verify the data's origin, and developers must maintain records of how they have trained the model and with which data. Unlawfully processed personal data can just disappear by changing hands. So if there's something which is wrong within one model, this risk will be transferred to the other users of the model. But Giulio, also this kind of opinion is stressing a lot the importance of preparing documents and working on accountability and being able to show to the authorities that you have actually done something internally. Do you think that companies will just be buried in paperwork, or do you also believe that there's some room for them to harvest and use these documents to prove their legitimacy in the data processing?
Well, Tommaso, I do believe that sometimes, and we experienced this during the last year or so, the provider doesn't disclose much to their customers on how their AI is trained, and even in the contractual terms, doesn't take over sufficient liabilities. We haven't even seen some cases where basically the provider was saying this is a high-risk technology. So if you, customer, your business are using that technology, you should take over part of the liabilities. So you should acknowledge that there is a risk exposure in using that technology. Honestly, with this opinion, and after the aggressive approach of data protection authorities and in the view of the coming into place of the UAI Act in the coming months, this is not a risk that businesses can afford. The time of the pilot projects probably is over, and companies don't just have to pile up documentation. They need to prove compliance, and probably so they need to run a DPIA, they need to run a legitimate interest assessment, they need to run internal audits, inquire their providers on how the technology is developed. And Tommaso, this is not addressed in the opinion, but I know that it's one of your hottest topics. There is a risk of requalification of the entity using the AI solution from deployer to provider, which makes the risk exposure even higher. Maybe you can unfold this aspect that is really relevant, even in the view of this opinion.
Yeah, definitely. I think this is one of the hidden risks that many companies are starting just now to realize. We have seen how this technology is evolving so fast, and even the board, in the first paragraph of this opinion, they clarify setting the scope. They say this applies to this specific piece of technology, but we know technology evolves really fast, so we know that this can change in a couple of months, even not years. So the same goes also with being having the risk of being requalified as provider according to the AI Act means for the company to that they have to comply with a wide number of obligations,
Yeah.
not just, incurring in more risk exposure in terms of financial sanction, but also in terms of things that you have to do and controls that you have to integrate within your structure, which can be expensive and also time consuming. And many companies, they know that, for example, they're not interested in fine tuning a model, but they might be interested in placing a model on the market under their own trademark. So that can be something which still triggers, the applicability of the provider's obligations. So that's something that companies should definitely make sure they carefully assess. In this sense, the opinion also introduces, Giulio, many risk management and mitigating measures suggested to the controllers.
No, absolutely. The opinion encourages a proactive approach to risk management. The privacy by design approach that is one of the backbones of the GDPR is also heavily addressed in the opinion. So privacy isn't something you can add at the end of a deployment process. It must be integrated from the beginning. Data minimization is fundamental. You need to collect only the personal data you actually need and consider pseudonymization or even better anonymization techniques wherever possible. Is that right, Tommaso?
Yes, exactly. And also regular testing is definitely one of the measures that is suggested. Testing against the known AI vulnerabilities is a key. We know that, for example, when we mentioned before the risk of extrapolating personal data from a model which was previously trained, what the opinion is saying, I think, is that guardrails are not enough. Being able to exclude that personal data is included in the output is not enough if personal data was indeed in the training dataset. So that's kind of a different shift of approach compared to the previous point of view of the Hamburg DPA, but definitely supervisory authorities will evaluate how a controller has tested its model, its resilience to such threats, and how many controls and safeguards they have implemented. We mentioned them before: differential privacy, encryption, access control. So the more the controller is able to prove and to showcase that they've actually implemented controls, the more they can build up a defense in case they cannot prove that there's full anonymity in their dataset, which we understand can be quite difficult to prove.
Yeah, exactly. And then the European Data Protection Authority digs into specific scenarios, something that is frequently forgotten is that legitimate interest cannot be the legal basis for the processing of special categories of data, and not even for data relating to criminal proceedings. And therefore, according to the board, in this case, organizations must have a valid exemption to consent for the processing of special categories of data. And when it comes to data relating to criminal proceedings, they need to have a law allowing that data processing. Otherwise, just that process cannot be performed. The same applies for automated decision-making systems. If they are run by artificial intelligence, you either need consent or you need to explain why there is a necessity to use that system. And we have seen very high sanctions in Italy by the local data protection authority, the Garante, for automated systems that were also powered by artificial intelligence, were considered to be discriminatory. Maybe you can expand a bit more on this field, Tommaso.
Yeah, I think, the automated decision-making point is just spot on, Giulio. The opinion sets a high bar for meaningful transparency and effective human oversight. So controllers must go beyond simply informing data subjects that AI models make decisions. they need to provide intelligible explanation of the decision-making logic and establish clear mechanisms for contesting outcomes. Again, there's a challenge here, and the challenge, I think, it lies in making complex AI decision-making processes understandable to the average person, while maintaining sufficient technical detail to enable meaningful contestation. This is a balance that requires thoughtful collaboration between the legal and the technical teams throughout the AI system lifecycle, and we have seen many times how difficult that can be. So definitely, the connection between the technical team and the legal team will be more and more important in the coming weeks.
Yeah, you mentioned the ICO, you mentioned the Hamburg Data Protection Authority. We know the initiatives of the Italian Garante, of the CNIL. The board encourages harmonization across the European Union. We will see whether it will happen. In the meantime, I think 2 weeks ago, we had a very famous position by the Garante against GEDI, a major Italian media group, where the Italian Data Protection Authority issued a formal warning to GEDI after discovering an agreement between GEDI and OpenAI. GEDI planned to provide access to its vast news archives to OpenAI for AI model training. But the Garante raised multiple red flags on the legal basis of the data processing, because basically the Garante said, look, we're not just talking about a license on IP rights. There is also a question of privacy compliance. So what is the legal basis on the individuals whose personal data are in the articles published by GEDI? Were the individuals aware of the usage of their data for AI training? Can GEDI guarantee the exercise of the individual's rights under the GDPR? Is transparency and accountability sufficiently protected through the measures put in place by GEDI?
Yeah, and I also think that this opinion, this real world use case emphasizes that even though these archives might seem just news articles, they do contain sensitive and potentially identifiable data. And so transferring this data to an AI model provider could make such model more capable of processing personal data, which again will go against the whole anonymity process that we have discussed so far. So this, I think, highlights that the opinion main message is organization must assess the legitimacy, the necessity, and also the fairness of their data uses. Large data sets are not exempt, so choose wisely before evaluating whether to share your data set with one of the large language model providers. So drafting some conclusions, Giulio, do you think we can suggest some practical steps for businesses to try and align with this opinion?
Yeah, I think all in all, the board identifies 7 milestones to be fulfilled when you are training or AI models with personal data, or you're using AI models. You should do a data protection impact assessment as early as possible and as often as possible to identify the potential risks and the mitigating measures. You need to assess the legal basis carefully. It can be legitimate interest, but legitimate interest is not just the legal basis that you need to use whenever you don't have other options on the table. You need to run a legitimate interest assessment, and that needs to be accurate. You need to implement privacy enhancing techniques, anonymization, pseudonymization, then maintain robust documentation, test the vulnerabilities, ensure transparency and communication. We spoke about the privacy, the legal design solutions. honestly, these are an element that is at the backbone of privacy compliance, because it can ensure a higher level of transparency, and then obviously be always in line with the evolution of the positions of the local data protection authorities, and also in view the GDPR compliance together with other laws that apply to artificial intelligence, like the AI Act, intellectual property laws, and other sector-specific laws.
Exactly, Julian. I particularly agree with this latest point of yours. Compliance is an ongoing journey, but we know that because of the digital decade, companies might feel overwhelmed by the amount and complexity of legislation which is coming out. So I think that those who invest in privacy by design, cybersecurity by design, AI ethics by design, and build the governance frameworks in time and implement the cost and risk assessments, they are better positions to navigate these complexities, maintain consumer trust, and actually win the market.
Yeah, I like your finale. Winning the market. It's absolutely right. If you are taking some risks, you risk to jeopardize the business of your company, which means you can jeopardize the future of your companies if you don't put in place the adequate safeguards. We always say to our clients, we need to find the right balance between business driven approaches. We need our clients need to make money, need to run their own business, to maximize revenues. At the same time, we need to find solutions in order to be able to argue that their conduct is legally compliant. Only in this way, compliance can be a driver of the future and the success of companies. So we reached the end. We hope that this session was useful. Thank you, Tommaso, and thank you to our listeners that we always encourage to share with us their views on our episodes. So please follow up with us, address questions if anything wasn't totally clear. Also, if you found this podcast interesting, please leave 5 stars on Spotify, on Apple Podcasts, on whichever platform you're using in order to watch or listen this episode. Thank you for joining us today on Diritto al Digitale. We will meet again in the next episode to continue exploring the challenges and opportunities of the digital world.